everybody. Sorry for my tardiness. We only have four bills that we're going to look at this morning. And then at the end, for anybody that wants to stay, I think we have a video that you may want to stay behind and see. And if not, that's okay too. You don't certainly have to. The first one is House Bill 1162. This is dealing with child abuse and revising the statute of limitations for claims. Comes to us from Representative Lamar McLean. And I believe all they're trying to do, Ethan, is to extend that out for a couple more years. Holly, you may know what. Okay. All righty. This provides for limitations for personal actions that are not specifically provided for in the law. It's been a while since I've read that.
Me too. Sorry.
It's okay. You can look at the language on starting lines 21. New person entitled to bring in personal action of felonious abuse or battery of a child is described in section 97.539, touching or handling a child with lawful purposes, sexual battery of a child, exploitation of a children. Yes.
Line 46, it repeals that section or section B by 2027.
Right. And I don't know what their purpose of that is. Holly, do you know?
Well, if I
go for it.
Really speculate, it looks there are across different states. I forget what they call the laws, but it's similar to what's going on in other states where they open up the statute of limitation. Some call it the Bill Cosby law.
Okay.
Where you have these issues that they were barred by the statute of limitations. So in particular instances, they opened up the statute of limitations
just for a window.
For a window period to allow that.
Gotcha.
Then that gets so in some of the just haven't looked. There's some states where if you saw there was kind of a flurry of lawsuits filed to get in under the new time period.
That looks to me like what they may be trying to do. I spoke briefly with Chairman Horan yesterday, and this was one of the House's big priorities, according to him. So that's the reason we're entertaining it in the committee this morning as a favor to Chairman Horan, our House friends. But that's what it does. Any questions?
Because if I may,
yep.
There's the general statute of limitations 3 years.
Right.
So it looks to be like that's open.
That seems to be what he was describing to me. So, Sparks.
A question, Mr. Chairman.
Sure.
My understanding is, if I'm looking at it correctly on line 20, there is a savings clause currently in the law that if there has been some issue, including the events named in section 2, that there is already in law a 21-year savings clause. So at 13 years of age, if I had been mistreated in this legal manner they're described, I have until I'm 34 already under law. What this would do is, I guess, unintentionally shorten that period, because it says not later than 10 years after I reach 21 years of age.
Right.
Well, in that scenario, you literally have shortened it, because if it occurred to me when I was 18, I get 21 years under current law.
Right.
And now this is backing me up to the age of 31. Then in
I think the savings clause only works once your disability has been removed by law. So like once you hit majority, you would be back under the 3 years unless there's some other unsoundness of mind that keeps you going, but I may be wrong.
Well, it says a person under disability. Now, unsoundness of mind is a different issue, but when I read disability, it says disability of infancy. Is infancy not
right? So
hadn't reached the age of majority?
When you hit 21, the statute starts to run, and you would have 3 years or 5 years or 7 years or whatever the statute is.
Okay, so
unless when you hit 21, you're also unsound of mind, and then then you would have,
21 more years.
right,
Okay. Well, that helps on the first part,
Mhm.
but this is none of this has to do with the crime, correct? All this is civil action. This is plaintiff's lawyer, language here. We're
Mhm.
not talking about criminal law. We're not talking about sentencing. We're not talking about crime, correct?
That appears to be correct, yes.
Okay, and then we're gonna open up a window from
Mhm.
July 1 of 24 to June 30th, 2027, that there shall be no statute of limitations. Somebody's 95 years old could come back and file a civil suit in some matter.
Which, if I may, is. I'm not weighing one way or the other, but that's been the trend in the states for various reasons. That people felt like it was unfair or whatever they discovered, or they were scared or whatever. And so states, hence the Bill Cosby, why it's been referred to as the Bill Cosby law, because my understanding is on the civil side, that's what happened with those cases. So, but I think Senator Sparks is accurate.
Okay, I just want to be clear, because obviously all these things are a crime,
Mhm.
and I don't want to be soft on crime, but this ain't about crime.
It's not about the crime.
This is civil court. All right, thank you.
Which, if I may, Mr.
Yes,
Chair,
you certainly.
That's also, I think the reason is because there is on the criminal side, the statute of limitations is run. Because it's a higher burden than in the civil cases. Going back and trying to convict with the higher burden after so much passage of time. But
Mhm.
then you have in the civil context, it's a lower burden. And it's not as, you don't have all the issues, but you're only dealing with money versus prison.
Gotcha. Senator Barr, yeah.
Trying to understand this. If someone was investigated for abuse on a child, like one of these crimes is listed here, and the DA decided to prosecute it, not to prosecute, not pursue it,
Mhm.
but that was 20 years ago. This would allow something from 20 years ago to be brought up and sued in the civil court, I guess, a civil suit. 20 years or whatever later. Is that what this allows for? After they made enough money.
Yeah.
Is that, am I understanding that right?
That's the way I read it.
Yeah, when the person is a minor involved on line 39 and 40,
At least for the 3 years, from 24 to 27, there's no statute.
right?
Then after 27, I guess the statute limitations in section 2A would kick in.
That is correct.
and it's only for minors.
Okay,
The minor could age out and be.
right.
Yes.
You're correct.
Adult.
Yes,
Or-
but when the person involved is a minor, when that happens.
Okay, I'm trying to understand.
I think you're correct. I didn't tell him we'd pass it. I told him we'd take it up. So these are all good questions. Yeah, that was a good question. Any other questions? All right, if not, do we have a motion? Anybody? All right, the motion is title sufficient to pass. All in favor say aye. Any opposed, nay? I think the ayes have it. The ayes have it. Okay. Thank you all for the good questions. The second bill, House Bill 634, there is a committee substitute. So we got the original bill as it came to us from the House first in the packet. You can see what they did essentially is this again is dealing with law enforcement folks who are retiring or leave employment after being employed for 10 continuous years of service. And the reason for that language, Chairman Horan explained to me yesterday, was that he's had some instances where people don't technically retire. They just leave one law enforcement agency and then maybe go work at another, but they've worked there for 10 years or more, but yet they're not retiring and wanted to purchase their firearm. And we're told they could not because under the statute, it says retired and they're not technically retiring. So on line of the old House bill, on line 11 and 12, it talked about the 10 years of continuous years of service. And then under the House version, should y'all want to go to that one, on line 16 through 19, it allowed them to purchase that firearm for $50, just a flat rate of $50.
Strike off.
And then on the strike all, if you go to it still includes the leaves after being employed for 10 continuous years of service on lines 11 and 12. But then the language we go to is that the state agency, board, or commission that employ the law enforcement officer shall determine an agreed upon price to be paid for the sidearm, which I think was language that Senator Turner Ford had offered in some previous bills that we had adopted. And the thinking on that is, I'm not a gun connoisseur myself, but I understand they can be quite expensive. So $50 is probably for a newer gun is probably way, way under reasonable market price or whatever. So instead of setting an arbitrary $50, what the strike all amendment would do is to say that the governing board, the sheriff's department, or whoever can decide what price to put on that firearm for purchase. So those are sort of the differences between the two versions. Again, committee can do as it wishes or nothing at all in this one, but that's the explanation of the strike all that we're talking about. Any questions? Yes, sir. Senator Hickman.
Just one question, and I may be overthinking as I tend to do. Would we, or do you think there'd be an issue with people, like particularly not the ones that retire, but particularly somebody passed away in the line of duty or whatever, or however this go, or somebody's attached to their sidearm? Do you think we would run into an issue where the entity may be upcharging the gun more than market value? Do we want to put some type of market value or no more than the price that was paid for the firearm or something like that there? I don't know. I mean, again, I may be overthinking stuff.
That's a good question. What do y'all think? Senator Sparks?
I guess on that issue, the agreed upon price, that would be pretty rough if some governing authority did that. I'm more worried about the other end of it, which I'm fine with agreed upon price, because then that state agency, board, or commission is responsible to the state auditor if they gave too low of a price. Because if the city or county wants to step up and pay the difference between the two, I think that's fine. So I like giving them the language to determine an agreed upon price. That way they can make sure they're compliant with the gift provision. But if they go the direction of Senator Hickman, we all need to pray for them. So
I need prayer. All right. Anybody else? Senator Norwood, yes.
For enforcement, there have been some type of background check, something like that.
Yes, sir.
I'm gonna require any type of background check for them to purchase that they may not be purchased or put on shelf. At some point in time, it's available to them. They may choose to use it. And putting a gun in the hand of somebody that may not have the good intention. Is that something that we want to do?
Well, that's a good question. Now, the part about, and you'll see in line 27, 28, and 29, that's already current language. So we're not changing that part. I mean, the next of kin of law enforcement officer who is killed in line of duty is authorized to purchase the sidearm that was issued to the officers. That's already current law. We're not messing with that. Now, I think your question is a good one, but I think it goes maybe more to the current law, not necessarily to anything that we're trying to change here. What I think we're trying to change to say that it would be as to an agreed upon price that they could purchase, not whether they could purchase or not, which is already current law. Okay. But if you want to make an amendment, certainly we'll recognize you for offering an amendment. Would you like to? Yes, sir, you're recognized. Sure. And are you on the strike all? You're talking about the strike all, yeah. Yes. That's his amendment. Questions for, yes, Senator Sparks has a question.
thank you, Mr. Chairman. I think, and I could be wrong on this, and if I'm correct, maybe it takes away the need for the amendment. But under the transfer laws, under federal statute, if that gun was gonna come out of the name of a law enforcement agency, it would have to be put into someone else's name. And I think that would trigger exactly what you're talking about, because that law enforcement agency certainly wouldn't want the gun to still be in their name and end up with somebody else.
I think that's a good point. Yeah. Good question. All right, Senator Barnett.
Thank you, Mr. Chairman. I'm an avid Second Amendment person. I strongly believe in that. But I understand Senator Norwood's concern, and I understood Senator Sparks' position on that as well. But we also have to be mindful that if there's an individual that's killed in the line of duty, there's a lot of sympathy from the community, the leadership of the community, the whole nine. And just that alone, we should make sure that we're careful in not just selling the gun based on our feelings to a person that may not necessarily need to be in possession of that firearm. So I think protection would be not to assume that the leaders would do those checks, but to have some protections in place, like the amendment that Senator Norwood offered, to make sure that those things are in place. I'm for them having a gun. I believe in that, that we all should have the right to bear arms. But I think that there should be some measures taken to assure that that those things are being done.
I certainly don't think it does any harm to the language, since, as Senator Sparks says, that's going to happen anyway, but us restating it certainly doesn't harm that, right? So the amendment, Mr. would go on line 27, subject to the successful completion of any required background checks, comma, the next of kin of a law enforcement officer, blah, blah, blah. Does that capture your amendment, Senator Norwood? All right, thank you, Mr. Samsel. All right, you've heard the amendment. Any questions for the author of the amendment? If not, all in favor say aye. Any opposed, nay? The ayes have it. All right, any other questions on the strike all as amended? If not, for motion?
Title.
All right, you've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right, thank you all. The next one, 724. Oh, I'm sorry.
And we adopted the strike.
Yeah, we adopted the strikeout. 724 is an expungement, clarifying expungement of pardon convictions. Now, on this one, again, in meeting with Chairman Horan, he tells me that he's had, and I can't imagine there's that many of these issues that comes up because we don't have many pardons. Certainly, I don't think there have been any issue in the last two administrations, and there were quite a few issued 3 ago. It's when Governor Barber was exiting office, there were a plethora of last minute pardons. And I think maybe this is where this is coming from. Apparently, Senator Horan has come into contact with some folks who received a pardon and then went to go apply for jobs. And on their job application, because that crime was pardoned, but it wasn't expunged, it still caused them problems from trying to get reemployed, back into the workforce as we're talking about. So he tells me that his bill is specifically directed at only individuals who are pardoned, who, again, that doesn't happen really that often, but for certain people, I guess, who have received pardons from the governor, it would allow those crimes not only to be sort of washed away through the pardon process, but also expunged from their record so that it doesn't cause them problems in getting reemployed and back into society. So that's what the explanation of that bill as I was given it. Any questions about that from anyone? Thoughts, concerns? Senator Spark?
It's any conviction that's been pardoned
Right.
is the language. So it would include things that are not expungable currently.
Right.
Is that correct?
I think that is probably correct. If
Thank
you've been pardoned, so would you have a concern about something that has been pardoned but is not currently expungible?
Says any conviction, that could be from murder on down, could it not?
Yep, it could.
I just want to make sure that I understood that. Thank you.
I think that's true. Senator Hickman?
So I think I think he's correct, because at this point, if you're part of something, could be expunged. this seems to be breaching those crimes that have been found.
All right, Senator Wiggins.
Thank you.
Mhm.
I was pretty used example since you brought up.
Yep.
Governor Barber, I distinctly remember pardoning a murder, manslaughter conviction of a firearm was used. And that was pardoned. So if we're doing what we're saying, then such things as manslaughter, not to expunge.
I think that would be the practical effect of this. Anybody have questions, further concerns? Senator Barnett?
Thank you, Mr. Chairman. I don't know the exact code sections on it, but there are some crimes that I know that we listed in a earned parole bill that we did.
Mm-hmm.
And I think if we could reference those in this bill, as those, if you are part of and can be expunged, I think we can satisfy some of it, but those that are not in that parole bill to be those that I don't think should qualify.
Okay, I'm sorry. Senator Hickman, you had a thought about that?
No, I had a question.
Oh, I'm sorry. All right, question, is this an amendment that you're contemplating?
Maybe with that, it's like
Is that already the current law though? I mean, if,
those that are in that, because it's just like violent, and then there's some that like carjacking for one is
Mhm.
one that was before was not a parole, you couldn't get any type of early parole, it was
Right.
day for day and those things, but those that are listed in that bill, in that statute that says that, that you can't be paroled for now, but you couldn't be, I think if we could list those,
okay,
then also specify those that we had that was in that bill that did not qualify for that. Maybe those would be the ones that not qualified for this bill.
okay, Senator Sparks?
So Daniel, I'm asking you for some.
Yeah, I was gonna question on the amendment, is that this is House language, correct? As
Yes.
it came to us?
Yeah.
So if we inserted a verse repealer as an amendment, then we could try to work on that language. Would that be amenable to you, Mr. Chairman? Okay, then I, at the proper time, I would offer.
You are
amendment to-
recognized, yes.
I would, offer the amendment to insert a verse repealer in the bill.
All right, you've heard the amendment. Any questions? All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. All right, any further amendment, Senator,
Question.
a question, Senator Hickman? Yeah.
I guess if we looked at how many people this would affect, that we probably should know.
That's a great question, and I have not, I mean, I asked Chairman Horan, I said, isn't it true that we haven't had any pardoned in the last two administrations? And I think he agreed that we had not. But then he said, but we did have quite a few in 3 back.
I guess my question. Also, what's the effect?
Right.
So, I mean, I would put in my support for the people that did this because it's not anybody that a governor of the state, we respect the office. Citizens put them there, it's not anybody but the governor of the state. I think it's charged for a crime, and I really don't think it's a whole lot. This would affect, but again, my question is, whatever you've done to lobby this party, what's the effect of it if they're still great crime, particularly job?
Well, I mean, they're out of jail, number one, so that's one big effect. But whether they can fully integrate back in society, I think is more the point you're making, which is a good one. Yeah.
Some people can get a pardon after they're already out of jail. Correct? So it's not always getting them out of jail. It doesn't have to be affected with that.
Right.
Then that would be one thing, but some people get a pardon after they're out of jail. They pardon them.
Gotcha. Good point. All right, any other, Senator Wiggins?
Mr. Chairman, I do have a motion.
Yeah. You're recognized.
So, my motion would be that we lay this on the table subject to call.
Mhm.
Sounds like we've got a lot of discussions that I think are good. I know that probably you and I will be having conversations with Chairman Moran.
Mhm.
And so my motion is be laid on the table subject to call.
And we will certainly be meeting again before the deadline. So, yeah, I'm not speaking in favor or against your motion. I'm just letting you know that if it's laid on the table, we would be meeting again and have the opportunity to bring it back off the table. All right, any other questions on the motion by Senator Wiggins? All right, all in favor of the motion, say aye.
Aye.
Any opposed, nay? The ayes have it. All right. And the last bill I think we've got on the agenda this morning is 1004, sex offender registry, revised definitions for provisions of law that regulate. All right, what are we doing on this one? Oh, you can speak to that, Senator Sparks. Thank you.
Thank you, Mr. Chairman. I have talked with Chairman Horan about this bill, and the issue that they're trying to cover is that people that are required to be on the sex offender registry and therefore have to disclose where they're living. There seems to be a problem that they are moving from place to place to avoid having to register. And so changing this to aggregate is a way to try to discourage that practice and say, look, we want you to live somewhere, we want you to be gainfully employed. You have been required by court of law to register as a sex offender, and that includes your residence. So you can't play this hopping around game to keep from telling the registry where you are. That's the intent of the legislation as I understood it from Chairman Horan.
And if you look at the line 146, the 3 asterisks there, the previous word was consecutive. So it's deleting the word consecutive and adding in lieu thereof the word aggregate based on what Chairman Sparks just explained the reasoning for that again on lines 209. I think it's same change there. Yeah, consecutive or yeah, that's what it is. All right, any questions, Senator Hickman?
I don't have an issue that I just want to keep understanding. So you're saying people are like staying 2 days here and staying 2 days here, 1 year. Is there like a time period, like 7 days within this period? I guess my question is, somebody say, got a job, travel to Jackson, once a month, maybe stay in a hotel with, in the aggregate for how long, and then maybe it was still an aggregate for how long.
Yeah, and I think that's exactly the concept, that if someone has a legitimate reason that their job carries them from place to place, they can register. You certainly can disclose if you want to. This is not for people who are trying to say, hey, I have this job and I move around. This is from people who are literally trying to avoid registering, and they're moving every enough days to stay off the radar. And they also cannot live within certain distances of schools, of other facilities. And if you are bouncing, like some cases they are, you're not even having to disclose that you're improperly near a school. And I actually had this issue within my district recently where mama lived too close to a school and Junior didn't live there, but he would come stay 6 days in a row, then go stay at the campground one night, and then come back, stay 6 more days. So in the aggregate, they would say, no, sir, you have to disclose this residence. And in that case, you can't live here. So that's all it is intended to do, is carry out the intent of, we need to know where you are. There's certain places you can't be based on what a court has ordered.
Okay, good question. Good answer. Any other questions? I know Stephen Clay back here with the district attorney, the prosecutor association. This is one of y'all's priorities, I'm understanding. Would you speak to that? All right. And for those stated reasons, I'm assuming?
Right. Much better than I ever could.
All right, perfect. Any other questions? Then if not for motion,
Thomas Fishing do pass.
last session,
I
do
guess-
pass.
Yeah.
All right, that's the motion. All in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. All right, before we rise and report, like I said earlier, Ms. Mabus has been good enough to bring with us, with permission of the law enforcement officer's family who was involved, a video showing that modified Glock switch weapon. So we're going to turn off our video link and we're going to ask, is it just for committee members and staff? All right, so if I could ask anyone who's not a committee member or staff to leave, we would appreciate